Welcome to the lecture on rights and laws. There are three sources of protection. You have the U.S. Constitution and Bill of Rights, you have federal law and regulations, and state laws. So what are the focus of rights, laws, and policies for persons with mental disorders? You have civil commitment, involuntary treatment, confidentiality and professional practice, non-discrimination in treatment and community living, and protection and independence. There are four main aims of civil commitment. First, to protect society from persons with mental illness who are dangerous, to protect persons with mental illness from harming themselves, to provide mental health care to those who need it but who may not appreciate the severity of their disorder, to relieve families and communities from persons who might not be imminently dangerous but who are bizarre and troublesome and who disrupt everyday life. It's important to be aware of the rights at issue for commitment and treatment. Civil commitment and involuntary hospitalization, voluntary hospitalization, the right to treatment, the right to refuse treatment and to have informed consent, rights in institutional settings, and involuntary outpatient civil commitment. There are some key court decisions that have articulated rights. In 1972, it was determined individuals subject to involuntary confinement preserved constitutional rights. Danger to self or others required beyond diagnosis of mental illness. And then a case in 1975, found by the Supreme Court, determined involuntary commitment cannot be incarceration. It must include treatment as a constitutional right. The Wyatt and Stickney case in 1972 from Alabama said that for involuntary commitment, the state must provide treatment and care that meets minimum standards. And then in 1982, the U.S. Supreme Court found that the right to safety and freedom from unreasonable restraint also deferred to professionals to determine whether treatment appropriately respected the patient's rights. Civil rights of institutionalized persons as of 1980. It was a response to the Willowbrook expose, covers many institutional settings like jails, prisons, facilities for persons with developmental or intellectual disabilities. The U.S. Department of Justice is involved in enforcement, conducts investigations, looks for patterns of practice, engages in litigation relating to conditions of confinement, does not file cases on behalf of individuals. There are some protections and advocacy via the Developmental Disabilities Act. It's a national network with a site in each state. Most are state-designated nonprofit agencies under public contract, about 10 state-operated. Mandate in the Developmental Disability Assistance of Bill of Rights Act of 1975. Since '86, a program called PAIMI, Protection and Advocacy for Individuals with Mental Illness. Until 2013, the New York State PAIMI agency was the Commission on the Quality of Care and Advocacy for Persons with Disabilities. This was a New York State government agency. The New York State Protection and Advocacy System. In a manner, it's similar to the Willowbrook. Hakeem brought attention to abuses in state-operated group homes in articles in the New York Times in 2011. The report, The Measure of a Society, was commissioned by the governor to further investigate. It was issued in 2012. As of June 2013, there's a new organizational structure for New York State Protection and Advocacy that includes protection and oversight of all persons in residential settings. Let's talk about merging different system mandates. Two agencies have been created. One, a New York State government agency, one, an independent nonprofit. They're responsible for the public protections across health, child welfare, mental health, and disability. The Justice Center takes complaints, investigates, prosecutes criminal actions, and keeps staff exclusion list. Disability Rights New York State Designated Protection and Advocacy Client Assistance Program Agency, and the PAIMI. Legal focus has shifted from inpatient to outpatient civil commitment. So, outpatient civil commitment laws exist in most states. It uses courts to mandate compliance with treatment, like taking medication, meeting with providers. The aim is to require compliance with community based outpatient treatment with penalties for non-compliance, often rehospitalization. It's interesting to note a little bit about involuntary outpatient civil commitment. So in New York State, there's Kendra's Law from 1999. The court ordered outpatient treatment requires evidence that individual is unlikely to survive safely in the community without supervision. There's mixed assessments about the need and appropriateness of court-ordered treatment. It's variable use across New York State as well. Continuing with this train of thought of involuntary outpatient civil commitment, there are still some legal rights at issue here. So, right to treatment in the community, right to public services and housing in the most integrated setting. There are employment rights, confidentiality and privileged communication rights, and of course, considerations for guardianship or conservatorship. There are some federal rights and non-discrimination laws for persons with mental disorders. I've got a timeline here. In 1973, the Rehabilitation Act, sections 503 and 504. In 1975, two were passed, Individuals with Disabilities Education Act, the IDEA, so essentially providing education of all handicapped children, and then the Developmental Disabilities Assistance and Bill of Rights Act. In 1980, it was the Civil Rights of Institutionalized Persons Act. In 1988, Fair Housing Act amendments, which added disability as a covered population. And in 1990, the Americans with Disabilities Act. Let's look at the Americans with Disabilities Act a little closer. Civil rights law for people with disabilities, similar to the 1964 Civil Rights Act in scope, remedies, and procedures. It applies to public and private employers and businesses, and it includes employment, transportation, public services, public accommodations, and telecommunications. The ADA has 5 titles. Title I focuses on employment. Title II is public service activities of state and local government. Title III focuses on public accommodations like private businesses, service providers that serve the public, new construction or alteration, transportation, and so forth. Title IV would be telecommunications, and Title V is miscellaneous. So how does the ADA define disability? Disability with respect to an individual is a physical or mental impairment that substantially limits one or more major life activities of such individual. A record of such an impairment exists or is being regarded as having such an impairment. The ADA Amendments Act of 2008 was designed to clarify congressional intent in the definition of disability and reject the interpretations used by the US Supreme Court. The intent is a broad definition of disability. The amendments address substantially limiting, mitigating measures regarded as standard. The ADAAA will assist persons with mental illnesses who also experience discrimination. There were some specific ADAAA corrections of Supreme Court decisions. First, the definition of disability in this act shall be construed in favor of broad coverage of individuals under this act to the maximum extent permitted by the terms of this act. Second, an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. Third, and finally, the determination of whether an impairment substantially limits a major life activity shall be made without regard to the ameliorative effects of mitigating measures, such as medication. Now, Title I outlines how employment discrimination is prohibited against a qualified individual with a disability. It's quoted, an individual with a disability who, with or without reasonable accommodation, can perform the essential functions of the employment position that such individual holds or desires. It's important to understand, too, that reasonable accommodation at work must be provided. So making facilities or equipment accessible, job or work restructuring, provision of equipment, aids, readers, interpreters, or other assistance. For people with mental health problems, common accommodations are later starting times, breaks, or quiet work areas. So what about Title II, the activities and programs of state and local government? You've got non-discrimination, service in the most integrated setting, enforcement through 7 federal cabinet agencies, ultimate responsibility with the Department of Justice, accessibility to buildings and to programs and services, and overlaps with the Rehabilitation Act, Section 504. Now, the public accommodations prohibit discrimination on the basis of disability in the full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodations. Public accommodations and services operated by private entities are also affected. Now, it's discriminatory to fail to make reasonable modifications in policies, practices, and procedures, which would enable a person with a disability to have the same opportunity as a non-disabled person to obtain goods, services, or privileges. For persons with mental health disabilities, modifications may be a quiet location, modification of procedures, or extra assistance. There have been some major successes of the ADA. Olmsted versus LC resulted in living in the most integrated setting. The difference between SSDI and ADA definition of disability. There are some changes in some aspects of employer behavior and greater access to and consequent participation in public life like shopping, entertainment, and voting. There are, however, continuing challenges for people with mental disorders. There's the disclosure dilemma, when disclosing helps or when it hurts. The stigma from the employer, coworkers, persons in other contexts. Determining appropriate accommodation at work or for services. All behavior is somehow now attributed to mental illness. Other problems are not examined or considered, and making community living a reality. So let's finish this up by talking about the UN Convention on the Rights of Persons with Disabilities. It's one of the many UN human rights conventions that fall under the Universal Declaration of Human Rights. The CRPD was adopted in 2006 and went into effect in 2008 after 20 countries signed it. The US signed the CRPD in July 2009. The Senate has not ratified it though. The CRPD both overlaps and extends rights beyond those covered by the ADA.